Hello and welcome to our webcast. I'm Amy Pendergrass with Moss Adams, and I'm going to get us started for today's session, the No Surprises Act, Part 2, the Good Faith Estimate. This is the final session of a two-part series with Foley and Lardner. And before we begin, I'm going to play a brief housekeeping video.
Welcome, and thanks for joining us. We're pleased to present another in our ongoing series of continuing professional education webcasts to help companies and individuals conquer challenges as they plan for what's next. Our presentation will start in a few moments. Before we begin, here are a few things to keep in mind. You can customize how you both view our presentation and interact with the presenter. For better viewing, close all other applications and turn up your speaker volume. You can also adjust window size and placement or enter full screen mode using the controls at the top of the window or dragging the bottom right-hand corner to resize. At the bottom of your screen, you'll see a series of icons, each relating to a different aspect of our session. You can download the group attendance sheet and a PDF copy of today's slides from the slide deck and handouts widget to the right of the slide view. You can ask our presenter questions during the webcast by typing a question in the Q&A window below the slide view and clicking Submit. We'll do our best to answer all questions during the presentation or follow up via email. If you experience technical difficulty during today's presentation, refresh your browser by hitting the F5 key. Today's session will offer you 1 CPE credit. To receive credit, you must meet the requirements as specified by the National Association of State Boards of Accountancy. You must attend at least 50 minutes of the session and respond to at least 75% of the polling questions, which we'll ask throughout today's presentation. To respond to a poll, click the button next to your answer. We'll track your progress and alert you when you've earned CPE credit. You can then click the certificate icon in the CPE Progress widget to open a PDF file that you can save to your computer. Don't worry if you can't download your PDF certificate today. We'll email a copy to you in 2 weeks. If you're attending this webcast in a group, you must complete our attendance sheet to receive CPE credit. The attendance sheet is available in the slide deck and handouts widget. Please have all group members sign it and send only 1 sheet per group. Also note that CPE credit can be awarded only to participants registered as themselves and isn't available to participants who view the on-demand version. As a reminder, the presentation you're about to see isn't legal, investment, or accounting advice. We encourage you to seek the counsel of a professional service provider to apply this content to your specific circumstances.
All right, today's webcast is eligible for CPE and CLE credits. To qualify for CLE, you will need to be logged into the console for the full duration of the program. If you're seeking CLE credit, please complete the attorney affirmation form located in the handouts window of your console. You will need to add the 5-digit CLE course code, which we'll announce later on in the program. Please sign and return the form to Patrick Brennan immediately following today's program. His email is on the screen and also on the form. And individual CPE credit is automatically tracked in your console. You will need to respond to at least 3 of the 4 poll questions and attend for a minimum of 50 minutes. And now that we have all of our housekeeping items out of the way, I would like to turn the floor over to one of today's presenters. Allie, the floor is yours.
Hi, everyone. My name is Allie Shalom. I'm an associate and healthcare attorney at Foley and Lardner, where I focus on healthcare transactions and then regulatory and compliance matters such as the No Surprises Act. Thank you so much to all of you joining us today. Welcome back to those of you who were with us last week, and thank you to any new attendees. We're going to go around and just introduce ourselves briefly, but today's webinar is going to focus on the good faith estimate for self-insured and self-pay and uninsured patients. I'll pass it off to my colleague, Kara.
Hi, everyone. My name is Kara Sweet, and I'm a healthcare lawyer with Foley Lardner as well. I'm located in our Denver office, and I also focus on healthcare regulatory compliance, including the No Surprises Act, conducting internal investigations, and defending government investigations. I'll pass it over to Lori.
Thank you, Kara and Allie. I look forward to our presentation. I'm Lori Laubach. I'm a partner with Moss Adams. I'm responsible for regulatory compliance and healthcare internal audit for our practice in Moss Adams Healthcare Consulting Group. I've been working with healthcare clients for over 30 years, and this is going to be a fun topic to chat about. So I'm going to pass it off to Mandy.
Thank you, Lori. So my name is Mandy Murray, and I'm a senior manager with Moss Adams as well in Healthcare Consulting Group in Strategy and Integration Practice. My focus is on service line growth and strategic development, and I'm located in Sonoma County, Santa Rosa, California, and passionate about the topic of good faith estimates within, the realm of No Surprises Act. So thank you all for joining us today, and we're excited to get started. I'll pass it back to Allie.
Great. So here's our agenda for today. Last week we focused on situations for patients who had non-government insurance, so for example, commercial pay and ERISA plans. Today we're going to talk about the good faith estimate for self-pay and uninsured patients, which kind of applies to a broader group of healthcare providers. After that, we're going to take a quick look at what is the patient-provider dispute resolution process. So what if something goes wrong with the good faith estimate? What if there's a discrepancy? What steps can be taken, and what is that going to look like? We're going to talk about, then we'll move on to talk about some tips and techniques for complying with these requirements and best practices as you begin to implement them. And then we'll finish up with some takeaways and some linked resources for everyone to be able to utilize and take home as you bring this back to your organizations. So you should all have our first polling question up here on your screen. The question is, what type of entity are you, or is your organization? So we'll give you a few moments to fill this out. But while you're filling this out, I do want to highlight that please feel free to put questions in the Q&A. We will do our best to answer those throughout, but to the extent we don't have an opportunity to answer your question because these are pretty jam-packed, our topic today is pretty jam-packed, we'll be in touch in the following week or two to answer those lingering questions. And I do see that some of the polling responses are coming in the Q&A inbox. There should be a way to actually click a response in the pop-up. And I see someone says they can't see the polling question. If you hit F5, that may be able to help a little bit.
And it looks like we have Thanks, Sally. It looks like we have a couple different provider types. We got some hospitals who are standalone hospitals, integrated provider groups, sole providers, and a fair amount of other category. The good thing is the good faith estimate applies to all types of healthcare providers and facilities, which we'll talk about further. So you guys are all in the right place. And I'll pass it back over to Allie to give a little bit more of a roadmap.
Sure. So this section of the No Surprises Act requires providers and facilities to provide good faith estimates of any charges of care being provided to uninsured or self-pay patients upon scheduling their care or upon request. And as we'll go into later, upon request is a very loose term, and a lot kind of can get roped in there. So we would recommend sort of having these ready or available for kind of most types of patient appointments. Second, the No Surprises Act creates a patient-provider dispute resolution process for uninsured and self-pay patients to contest charges that are substantially in excess of that good faith estimate. So again, as I mentioned before, what happens if something goes wrong with that good faith estimate, which, again, just an estimate ahead of time. All right, so I am going to pass this back to my colleague Kara to talk about the requirements and who's actually eligible for these.
Hi, everyone. So first, we're going to talk about who is required to provide a good faith estimate. And like I mentioned before, it's a very broad term. It includes healthcare providers, which is defined as any provider kind of working within their scope of practice. And then healthcare facilities is similarly very broad. It's institutions that are licensed by the state to provide healthcare services. So we've had some of the examples on the screen of healthcare providers are physicians, other providers acting within their scope of practice, and air ambulance services providers are particularly called out. Similar for healthcare facilities, Think hospitals, outpatient departments, ASCs, laboratory centers, imaging centers. Kind of, if you're licensed by your state, this likely applies to you. And on the other hand, who is eligible to receive a good faith estimate? It's typically uninsured and self-pay. And so self-pay are those who may have insurance but are choosing not to use it for this particular service. It is the obligation of the healthcare provider or the healthcare facility to determine if the patient is uninsured or self-pay. Who is not eligible for GFEs, similar kind of to our balanced billing piece. It's not for Medicare, Medicaid, Indian Health Services, VAs, or TRICARE patients. It's specifically targeted to the uninsured and self-pay group. And so next on our screen is a little bit of a diagram of how to operationalize these requirements. So like I said before, it is on the healthcare provider or healthcare facility to determine if the individual has healthcare insurance and if they're using it. So if the individual has health insurance and they're going to use it, then a good faith estimate is not required. But if the individual doesn't have health insurance or the individual has health coverage but chooses not to use it, then a good faith estimate is required. And there's particular timing requirements to all of these. I don't go into all of them here, but the main ones are for services scheduled 3 to 9 business days in advance, then the good faith estimate must be provided no later than 1 business day after the date of scheduling. For services scheduled at least 10 days in advance, so whether it's 10 days or a month or 2 months, a good faith estimate must be provided not later than 3 business days after the date of scheduling. And then third is when a good faith estimate is requested, and as Ali mentioned, this is a very broad term. Any sort of question related to payment must be considered a request for a good faith estimate. That must be provided no later than 3 business days after the date of this request. Mandy, do you want to jump in here?
Yeah, I do actually, Kara. Thanks for asking. So one of the things I think we want to call out here as we work with our clients is a common confusion area comes in is between when exactly the good faith estimate is needed. So when I read a lot of online articles or mentioning about good faith estimate when they're being provided, some of the articles will stop short saying that if a patient is scheduling care at least 10 days away, a provider must deliver the estimate within 3 days. And they don't call out from when, within 3 days after the date of appointment or, well, basically from an appointment or from a time of scheduling. As Kara talked about, it is really the date of scheduling or even basically the date of the request came in that is really the key, is not the date of the appointment. So some of our clients that we work with, initially when they were trying to work in the requirements of the Act, they were under the impression that the appointment is scheduled a month out. So basically the GFE is not required within until 3 days within the appointment date. And so we had to remind them that the date of scheduling is really the key. Again, it's not the date of the appointment, while it is an important time frame for us to figure out when the appointment is scheduled out from. But it's really the time frame of the GFE required is from the date of scheduling. So I want to make sure that you all are familiar with that difference there. The other thing actually that comes up quite often when we're working with our clients is that some of the patients are not eligible for insurance at that time and are expected to be eligible. So for example, some patients might become eligible for Medi-Cal as they're exiting, they're basically uninsured at the time of the scheduling the appointment or at the date of the request of the appointment. So because it's going to be eligible down the road, some of our clients have asked, would a good faith estimate really be required because they may be eligible in a few days? And the answer is still yes, because at the time of the scheduling or at the time of the request, if the patient's uninsured, as this chart is telling us, the good faith estimate is required unless, patient is basically going to be using insurance. And if they're basically using insurance and they're not letting us know, that still basically qualify as somebody who are not using insurance because at the time you ask the question, the patient's not intending to use insurance. So we just want to make sure you call out the difference there.
Yeah, and it looks like we just had a question come in asking about if doctors see patients in a hospital and they don't know if a patient is insured or not, whether the hospital is required to provide the estimate. And so kind of this goes back to when we're scheduling service. So if they're in a hospital, that is not a pre-scheduled delivery of item or services, and therefore a good faith estimate is not required. Kind of the trigger point is the 3 business days in advance is when a good faith estimate is typically required.
Yeah, it calls out the importance to check whether the patient, so like a first step that you need to ask the question, does the patient have insurance or intend to use insurance?
Yeah. And so we kind of talked a lot about kind of the eligibility and requirements, but we haven't yet talked about what a good faith estimate is. So these are your expected charges that you would expect to receive for such a service, whether that's a cash pay rate or the amount the provider or facility would expect to charge if the provider intended to bill the plan or insurance. Notably, expected charges include estimate of no financial responsibility. So even if you expect that patient would pay $0, a good faith estimate is still required. Mandy, do you want to give some examples of when we see this?
Yeah, definitely. So one of the really common example would be a post-op visit, right, from a surgery. And so if the post-op visit is already included in the surgery GFE, which is part of the global, the actual good faith estimate will not be necessary for a post-op visit that was already included prior. But if it was not included prior, post-op visit, which is usually zero charges on the charge master, will still require a GFE. It was, again, not included. So in some county hospitals, if they have basically nurse visits, again, going back to your charge master, if you see a zero charge on your charge master, it does not mean that you don't actually provide a good faith estimate, because it is still expected that a good faith estimate needs to be issued, even if you expect the final charges to be zero. So that's what the basic requirements call for.
Thanks, Mandy. And so the good faith estimate must include kind of the expected charges for the primary item or service that's going to be provided to the patient during a period of care. And notably, a period of care is defined from kind of admission through discharge. If there are separate good faith estimates kind of needed for things that are beyond the period of care, then those can be provided by those particular providers. Some examples of what a primary item or service is are listed up on the screen. One thing I'd like to point out is there are requirements between kind of convening providers, which is the provider that is asked for the scheduling, versus co-providers who are providing services in conjunction to the convening provider. There are requirements kind of for communication between these two for creating the good faith estimate, but those have been, there's enforcement discretion through the end of the year. And so now I'm going to pass it over to Lori to talk about some of the risks related to a good faith estimate.
Thanks, Kara. Well, there's a whole bunch of risks that are probably popping through your head right now as you're thinking about everything that's been discussed, and hasn't been that many slides yet. So we still have a lot of slides to go through. But I think some of the things that I think about is just the whole workflow of the GFE and how you can actually implement some things related to timelines. So if an appointment's scheduled, it's a self-pay patient, uninsured patient, excuse me, or self-pay that's opting, then you would need to start that workflow. And it needs, the American Hospital Association has noted in a report that it's going to take up to 10 to 15 minutes per each GFE to complete. So how do you staff that? How do you make sure that you can turn that around and meet the demand? We can talk about full automation, but there may still be some issues you have to deal with because some of these situations are very individualized by patient. So we need to make sure that we look at that the preparation, because often that's very manual and it does require some employee intervention to make sure it's accurate as best as possible, as that's part of the requirements related to GFEs, is making sure you have a policy, you have accuracy of range of estimates. At the start of this implementation, you probably did a lot of training, but I think one of the biggest risks we have in a lot of organizations, we do training, but we don't keep updating the training according to what the workflows that we have. So make sure that that continually is pushed out and employees can actually see that. There is a need to be as accurate as possible in the preparation of the GFE, but the phrase good faith essentially requires honest effort. This includes making an effort to capture all the charges that would likely apply to an individual's expected course of treatment. GFE are not perfect estimates, but they should account for foreseeable charges, but that's not, it's a generic estimate or a list maybe of a bundle price for things, or, coming up with some pricing scenarios with those other providers that may be involved later on as that becomes required. And I think the last one, a couple things on here is, sometimes in some practice areas such as psychological care or primary care, the healthcare provider may not know how much treatment is necessary for a new client, so a range of costs may be appropriate. If that range is used, the the factors can result in a lower or higher range should be identified. So they can state 10 and 25, 50-minute sessions are needed each year, and then how much that might cost per session, and then continually update it as you find out new information about that patient. So Allie, it looks like we have a discussion question next, so I'd like to move on to that next area.
Sure. So our first discussion question is going to be for Kara. So if an individual schedules a birth of a child, what are some types of things a good faith estimate for that might include? What types of items or services should be listed there with estimates?
Yeah, there's a couple of things I just put on the screen there. We need to think about kind of the physician professional fees, room and board, anesthesiologist professional fees, facility fees, prescription drugs, laboratory tests, kind of anything that could be expected within the course of a birth of a child should be included within the good faith estimate. And this will require talking to various co-providers and co-facilities. And I think it's important, as kind of Laura already mentioned, that the onus is kind of on this convening provider facility to really give to the patient the full picture of the cost of a particular medical event. And that means kind of communicating with these in-house providers, having consultations and follow-up care, and thinking through kind of what does this patient's care look like from admission to discharge. Mandy, I'm going to pass it over to you for an example.
Yeah, thank you, Kara. So, we would like to think that we can all schedule the birth of a child exactly on the dot, right? But there are definitely occasions where you have a complication during the birth where maybe it was a scheduled vaginal birth that became an emergency C-section as an example. So it's not uncommon, it does happen, right? And so a scheduled C-section is also something that does happen as well. So, but there's a difference between a planned versus an emergency C-section. So obviously the difference is the urgency and, immediate concern for the safety of the mom and the baby. And so that's when you need immediate intervention that you had initially had planned for either a vaginal birth and converted to an emergency C-section. That's when I think things change quite a bit in terms of the context. So in the case of emergency C-section, a good faith estimate would not apply because, again, it's emergency. Just going back to basically like an emergency services, basically. In this case, is a birth that the good faith estimate would not apply versus a planned vaginal birth that you have planned in advance, that you know that all these services that you can potentially anticipate will be included. So I think that's something to be just thought about differently when it's scheduled elective services versus a emergency service.
Thanks, Mandy. And just to be clear, just because a good faith estimate doesn't apply, it doesn't mean that there aren't additional balance billing prohibitions that might apply. So you need to kind of go through kind of all of these different analyses when you come to making this decision. Next, I'm going to pass it over to Allie for a polling question.
Great. So our next polling question here is, has your organization established a workforce with internal controls related to a good faith estimate? So kind of where are you in the process of getting this all up and running? And while we do that, we just want to I want to take a look at some of the questions that have been asked in the chat. So we're going to talk about additional services later on in the presentation. And some of the most recent questions, I think, are going to be covered by our next discussion topic. But for now, Kara, I don't know if you want to take question 11 and 12. Are there requirements for the health plans regarding the good faith estimate? And does this apply to dentists as well, or just hospitals? Who are the providers that this applies to?
Yeah, so it applies to healthcare providers and healthcare facilities. So that would kind of exclude health plans, at least for now. Health plans may be involved in the good faith estimate process starting in 2023, but we don't know what that looks like yet. So in regards to dentists, it would apply to dentists. They would be considered healthcare providers working under their scope of practice.
Great, thanks. Oh, and just in time for our results. So it looks like we're kind of a little bit all over the map here. Some people have started in various stages, and some people haven't yet. And I think that's sort of what's expected at this stage. We'll talk about kind of enforcement delays a little bit later on, but I think the government realizes this is a lot of legwork for providers and something everyone is still figuring out. So I will pass this back over to Kara.
Thanks, Allie. So next is kind of what is it, a notice of a good faith estimate? It is a requirement to post a notice of a good faith estimate on a website and on site anywhere scheduling can occur. The government has provided kind of form language that entities can use that I've posted on the screen right here. Next is what's in a good faith estimate. We've had some questions come in asking if you are required to use the government's good faith estimate form. You are not, but you are required to hit all of these bullet points and put the disclaimers in the exact spot that the government form did. So it may be easiest to use the government forms, but you can make it unique to your organization to the extent you still meet all of the requirements listed here. Importantly, the good faith estimate must be provided in a written form, whether that's on paper or electronically. While it can be provided orally, you need to follow up with a paper electronic form. The patient must have something documented that they can print out and read. And this must also go into the patient's medical record and maintained in the same manner as a patient's medical record. Now I'm going to pass it over to Lori to kind of talk about the good faith estimate and notice risk.
Yeah, I think some of the things I worry about when I start to look at the different risks that have come up, one is really around the workflow for the provision of the notice and the posting of the notice. We have so many notices and that we're giving to our patients, and our staff is very busy during that, during the workload and everybody coming to the front desk and all these different information. So we just really need to make sure that there's a written workflow in place to figure out, what to do and how, if things may not be written, how do you have the workflow put together? And establish, I think one of the key things is establishing some type of process to cue the need for that completion and delivery of the GFE following the scheduling of an item, which could be an automated process once the scheduling happens, it's an uninsured patient, it goes straight to the GFE team, and they go ahead and get that prepared. Revenue cycle also, the team needs to have strong internal controls related to ensuring patients' statements align with the GFE, and if there's any additional unforeseen cost or anything like that are reviewed before sending to the patient, especially if it's greater than $400 per provider. So I think it's important to make sure that you have some workflows related to this. The posting of the website, I think one of the things to think about here is the organization chooses to provide in person or through mail or email. There's a risk of proving that it's been provided to that patient. Regulations do not require a facility or provider to secure a written acknowledgement of receipt, but a facility may want to, or provider may want to follow the same procedure employs for other required notices just to demonstrate compliance. These should be retained in the patient's record. A few other things on here is around, we've talked about it before, is accuracy, completeness, and that the GFEs are thorough and include all elements required for the GFE recommended by CMS, as Kara was showing you before. What are you going to put in place to audit that we're accurate? Accurate's always a tough one, but making sure we have data integrity and that you're compliant. And if you use software, is that software being vetted to make sure that it's providing the most latest, greatest prices, and you're not going to have an error related to that? And then I think the couple other things on here I'm going to mention is just making sure that we consider the financial assistance policies as we prepare the GFE. So we have an uninsured patient, we're looking at their, having them fill out a form if they need to have some assistance and applying that in the development of the GFE. And then one of the things we want to also think about is if we do have some unforeseen circumstances that come up during the care of the patient, that we document that, we retain it, and a good faith estimate is considered part of the patient's medical record, and providers and facilities must retain it and be able to provide the patient with a copy of any previously issued good faith estimate from the prior 6 years. So keep that in mind. You need to retain it in the record and be able to pull it out if you need to. Allie, it looks like we have a couple discussion questions to go through next.
Yes, we do. Thanks, Lori. So our second discussion question of the day here is, does the good faith estimate and PBDR apply to cash-only providers? And when I think about a cash-only provider, this might be like a direct-to-consumer telehealth company where the patient is paying and the provider's not contracted with the insurance company.
I can answer this one, Allie. So I think I keep on going back to who does this apply to? And it applies to almost all healthcare providers and healthcare facilities who are working in their scope of practice or licensed by the state. So it would apply to cash-only providers. A lot of cash-only providers I see in kind of my day-to-day, they post the price online. It's either a subscription fee or kind of how much the services cost. Unfortunately, that does not count as a good faith estimate. So it's because it doesn't meet kind of the requirements we talked about before with having to do all those bullet points and disclaimers and put it in the patient's medical record. Just having the cost on your website or through kind of the Price Transparency Act doesn't count as the good faith estimate. Now, I've rarely seen those estimates change where, the price online is $100 and the customer gets charged $500. But it is something that is to know that just providing the cash-only price on the website doesn't meet kind of the technical requirements of the law. Mandy, do you want to talk us through kind of some examples where we see this?
Yeah, thank you. And I think I probably think about one exception about price changing is like going to a cosmetic plastic surgeon, right? When you are trying to get a procedure done and you go in for a consultation, and that's when maybe the price will dramatically change from the time that you actually see what is estimated on the website, like you said, Kara, versus like what truly is going to be provided to the patient. But some of the examples of like cash-only providers, like acupuncturists, that itself, most of the insurance companies may not be covering the service right now. Therapists in general, but like I said, cosmetic plastic surgeons or even dermatologists who usually bill insurances, but provide some services, again, cosmetic procedures, not medical dermatology, but cosmetic dermatology. They don't accept insurance and they basically do cash pay only. So in that instant, there's another factor that comes into it is how far out, again, is the appointment being scheduled. So earlier, Kara had covered about the flow chart about the timing of the GFE. If it's scheduled, between 3 to 9 days, or is scheduled basically less than 3 days, or is it scheduled farther than that? So depending on how far the appointment is scheduled, for those kind of cash pay patients going to these kind of specialties, if they're scheduled during those timeframes, then the requirements of the GFE will come in accordingly. But then there's also the concierge practices, right? You got concierge practices that membership only but still bill insurance. And then you got those as cash pay concierge practices. Some of them call them direct primary care. So those you pay to get access, very quickly, and sometimes within 24 hours you can get in. So in those cases where you can get in as a patient within 24 hours, the concierge practice, then the good faith estimate would not apply only because it is scheduled, basically less than 3 days from the time the appointment is scheduled less than 3 days from the time that you called or to the time you scheduled. I'm going to pass it back to Allie to start us up on question number 3.
Great, thanks, Mandy. So discussion question 3 here is what happens when there are changes in the scope of a good faith estimate, such as changes to the expected charges, items, or services, and changes to the provider or facility. So, Kara, I'll pass this back over to you.
Yeah, I'll tackle the first one about the changes to the expected charges, items, or services. This kind of goes into 2 buckets. Do you know about it or do you not? If you know about it, it likely does need to be included in the good faith estimate and included within, the correct time frames. I would say even if it's, it comes up the day of service, I would try to include it as well as kind of a best practice. Kind of on the other hand is these unforeseen items or services, which we'll discuss more about in the patient-provider dispute resolution process, but want to just flag it now that they do happen. There's ways to address it. And I'll pass it over to Mandy to talk about the changes to provider or facilities.
Thanks, Kara. So if the change to the provider or the facility is happening less than 1 business day from the date of the appointment or the service, the replacement provider or the facility must accept the GFE for the relevant items and services being furnished that was provided by basically by the replace a provider or facility. So in essence, they must accept it as it is if it's less than 1 business day notice. If it's basically more than 1 business day notice, so the new provider, the new co-provider, the new facility must provide a new estimate to the patient within 1 business day. So that probably is the only difference is you accept as it is, or you provide a new good faith estimate. I'm going to pass it back to Lori. It's going to set us up for how you audit a GFE.
Yeah, thank you. I was also going to mention one of the questions I saw pop up here was about if you have a new patient and you don't really know their diagnosis yet. And as Kara was saying, it's what you know, but it's also, I know many organizations have set up what they call a new patient estimate, and they communicate that with the patient before they arrive. But then you can adjust it as you know, what the next fee will be if they continue care with you or something like that. So it's that communication, that constant discussion with that patient as you work through these type of situations. So steps for auditing of the GFE is really gathering all the facts and the information. And I have several questions on here, but you want to find out really what the workflow is, and you want to verify that our team is actually meeting that expectation and where the greatest barriers are for them. It's not just about whether or not we're doing it right and we're being punitive, but it's making sure that we look at the internal controls as well as data quality, and in addition, how we track and monitor those GFEs, and where do we put in the controls to prevent things from being billed inappropriately, and having them pay more than what's in the GFE or greater than $400 that we're going to talk about a little bit later. And then what type of trainings occurred, and can we say that the training and the policies have changed over the period of time, and what did that mean to our organization when we go in and we start testing some of the GFEs? It's really making sure that we have the internal controls, or we're monitoring that we're completing this properly, and we're trying our best to make an effort to get this GFE out accurate as possible. So I'm going to hand it back to Allie, and we can continue on.
Okay, so we're going to now transition to sort of the second big topic of today, the patient-provider dispute resolution process. So what happens if the estimate is inaccurate or off for some reason? What does it mean for it to be inaccurate as it is an estimate? And what are the dispute options available to the patient? So I'll pass this back to Kara to get us started.
Thanks, Allie. Yeah, so next we're going to go into the eligibility of the patient-provider dispute resolution process. There are two things I want to point out. One, there are options for state patient-provider dispute resolution processes. They have to be approved by HHS in advance, but those may be occurring in your state. Today I'm going to be talking about federal only. Additionally, as we mentioned before, there's enforcement discretion related to the co-providers and co-facilities in relation to their good faith estimate. And so what is to be eligible for the patient-provider dispute resolution? This is between the patient and the provider, not to be confused with any of the different dispute resolutions between the plans and the providers. This is focused on the patient and the good faith estimate. So this is eligible to individuals who receive a bill that exceeds the good faith estimate by $400 or more for the total expected charges. This is not itemized, this is bottom line, and it's for each provider. And so next we'll show kind of an example of what one looks like, and I'll pass it over to Lori to describe it.
Yeah, I just wanted to, we put together some examples to try to compare and talk through the PPDR process, or, you know, what is actually placed. And just this example here shows some of the detail, but I want to caveat that that this doesn't have all the elements of the GFE, because otherwise you would not be able to see everything that's needed to demonstrate this. So this is an example of a GFE for when surgery is done by a physician-owned ASC and not at the hospital. There are various locations that are owned by the same medical group, and when we're creating this, we didn't look at, you know, all the other regulations about PT and all these other things. But the key here is each line is the service that's actually being provided to the patient, and this is the expected cost that we think is going to be charged at the end. And so this is a knee surgery that we've given, and you can see here the different fees, and it could be in the hospital, it could be from admission to discharge, it needed to be added to it. Let's just stick with this example as we walk through the process. Next slide.
Yeah, so now I'll talk about how to initiate. So a patient has a bill, it's over $400 in total, greater than their good faith estimate. they are able to notify HHS within 120 calendar days of receiving their bill in order to kind of start this process. And what they have to do is they have to provide kind of all of their information related to the good faith estimate, the bill charges, and pay a $25 administrative fee. Now that $25 is a current fee, and it could change throughout the years. After this happens, HHS selects a selected dispute resolution entity, also known as an SDR, and they provide notice to the provider. So the SDR, when they provide notice, they'll reach out to the provider, who will then have an opportunity to submit their side of the story and their information for the SDR entity to consider, but they must do so within 10 business days of the receipt of the SDR entity's notice. And next we'll do a polling question to figure out what types of documents are required or can be submitted in response to an SDR.
Thanks, Kara. So heat up the exact polling question. So what can a provider submit to the SDR? So everyone can take a moment to fill that out. And while you are, Mandy, I wanted to point out one of the questions in the Q&A related to your vaginal birth example. Generally, that's not a scheduled service. So do you mind clarifying?
Sure. So, for every birth, well, I should say that if someone is going to give birth, there is a predicted birth date, right? There is a birth day that is actually predicted to when the baby is going to be born. So in that sense is that when you actually do see your provider and you do actually get into what kind of services will be provided, either is vaginal birth or C-section, that is determined by medical necessity and also by the basically by the preference of the patient. If the patient decided it's going to be a vaginal birth and there is going to be a certain date range where the baby is going to be born, it is in a way expected. What is a little bit different is if the water broke and basically the patient is going to be going into unexpected like labor, then that is a very different situation where, yeah, the patient could be a vaginal birth and it could be unexpected. It could be an emergency too. But for the most part, like a friend of mine, she knows that she was going to go to the hospital. She knew that she was going to be, around that date. So in a way it is, and she chose to have a vaginal birth. It is scheduled in the sense is that, again, it depends on the circumstance of the pregnancy at that time. So I can't speak to specifically if vaginal births are all scheduled or they are basically emergency. It can be either or situation. But if it's, again, you know there is going to be it's a planned birth, you decide that it's going to be a vaginal birth, you decide that it's going to be between the dates of this day and that day that you expect the baby to come, then it is something that you know of, that there should be a good faith estimate basically about the services that come along with the birth, be it basically a planned C-section or a vaginal birth. Hopefully that helps.
Thanks, Mandy. I think that was a really helpful clarification. And here we have the results, all of the above. So we're now going to talk about what the PPDR process is going to look like. So Karen, if you can describe what this is, what the process is.
Thanks, Allie. So once kind of both sides submit all their documentation, including the good faith estimate, the billed charges, and any sort of evidence related to unforeseen charges, it's up to the SDR entity to review kind of all this documentation and make separate determinations for each item or services. So while we get into kind of when are you eligible for PPDR, that we look at the total billed charges, but when we're actually in the PPDR process, we're looking line item by line item to determine this. And so if there's anything new, anything that wasn't on the original good faith estimate but is on the billed charges, then the SDR entity needs to look and see whether there's credible information to demonstrate that the difference between the billed charge and the expected charge reflects the cost of a medically necessary item and is based on unforeseen circumstances. And they need to do this within 30 days. So next we go through kind of what is it. So if it's less than or equal to the expected charge, then the patient will have to pay the billed charge. If the billed charge is greater than the expected charge, then they pay the expected charge. And if it's greater than the expected charge, and the provider provides credible information to justify the charges, and credible information kind of means it's truthful, it's believable, then the amount to be paid is either the lesser of the billed charge or the median payment amount. And so then when we're looking at items or services that do not appear on the GFE, so these are things that we do not anticipate, the SDR entity determines whether the provider provided credible information. If not, if the provider doesn't provide this credible information, then the amount of the new item or service is going to be equal to 0. And here's an example of what the SDR entity could send when it makes its determination. It's a form letter provided by CMS. And so next we'll get into a discussion question that I'm going to push to Lori.
Yeah, thank you. So we're going to try to go through these real quick in our last 15 minutes of the presentation. But we put together some different scenarios. And this one here is a first example of a GFE where after the surgery is done, there are some variances. So remember that original 2,125 from the previous GFE that we looked at. We now have a bill charge of 2,400, which is a difference of $275. And that is less than $400, so that means that the patient cannot dispute the bill. Any other items that you'd like to discuss on this one, Kara or Mandy?
No, I think that really covers it. I think important here is to look at kind of each line item is under $400 and the total is under $400. So this person is not eligible.
Right. And then the next slide that we have is the bill charge varies to the GFE. So in this case, we had, my math isn't very good at the bottom, but we have a difference of 575. I think my total under billed charge is incorrect. But anyway, the difference between the variance columns, we had $300 more on physical therapy, knee surgery, $225. All adds up to $575 greater than that. And that is greater than $400 and that means that the patient could dispute the charge. So, but it isn't by the individual line at this point, but it will when you go to PPDR. So we'll go to the next slide. And then on this one, we actually have an additional service that was billed that was not on the GFE. And Kara had walked us through the different, what needs to be done in order to support that additional charge. But it's over the $400, just slightly over the $400, but it's because of that $200 additional charge. But none of those are individually over $400. Any additional comments, Kara, about that one?
Yeah, so I think this is kind of an important one to show, like this new service, even though it's not over that $400, right? The entire bill is over $400, therefore it has the possibility of going to the patient-provider dispute resolution process. And so for that service that is not included, the SDR entity is going to go through and determine whether the provider provided credible information that this is medically necessary and it was unforeseen. And so I think this is kind of an important point for processes to figure out if something is added that wasn't on the good faith estimate, how to go about kind of documenting those changes.
Yeah, Kara, actually, this is a question that came up earlier in just in the Q&A box as well. So a lot of specialists, when you actually see a patient, you may be seeing them for a typical E&M as a consultation. But during the time that you see the patient, you may see something such as a wound care clinic. You don't know what you're getting into until the patient shows up with a wound and you open up the bandages and you start seeing things that you need to operate on immediately in the office. And so that may not be part of your typical service that you provide, at the time of the good faith estimate. And even if it's medically necessary, it is definitely important to document that because it will serve its purpose when you go to this PPDR process, especially when the final bill does vary from your good faith estimate because of the new services provided. Regardless of whether it's medically necessary, the patient still has an option to basically go through the PPDR process.
Thank you. And I had already pushed to our last example. Sorry about that, Mandy. And that is related to where we have two providers. So this is provider in a different entity, and they did the assist on the surgery. When you look at the grand total, it's $575, but it is not greater than $400 by provider. So if you look at the $375 versus the $20, it is not over the $400. So this would the patient would not, oops, sorry. I thought I had another cute little arrow, but this one is not actually something they could dispute. Now let's just say that the knee surgery assistant went over, was like, went up to $600 or $800 than as the bill charged, and definitely it would be in a situation where the patient could dispute the provider to entity bill itself. Any other questions on that, Kara?
Yeah, I think you covered it.
Okay, I'll let you go on. Yeah.
So next I'll talk about kind of what can you guys do during the SDR entities process. Well, you're allowed to do alternative negotiation, which means the provider and the individual may separately agree on a payment amount any time prior to the date on which the SDR entity's determination is made. So that may include offering financial assistance, offering a lower amount, or reaching an alternative agreement where the individual pays the bill charges in full, or kind of any combination or what you guys can think of that they would agree on. And if you guys do so, then you must submit to the selected dispute resolution entity the agreement. And you must do so within 3 business days of coming to that agreement. And then I want to flag that during the PPDR process, once you are alerted that it is ongoing for that individual, there's a prohibition on collections and prohibition on fees. So that means the provider must not move bills into collections or even threaten to do so. And if the bill is already moved into collections, then the provider must cease collection efforts. Additionally, there's a prohibition on fees. The provider must suspend the accrual of any late fees on the unpaid bills until the PPDR process has concluded, and the provider must not threaten or to take any retributive action against the individual for using the PPDR process. So next I'm going to pass it over to Lori to talk more about the risk.
Thank you, Kara. So some of the risk areas on here, I worry about the time period, and Kara had provided a list of different time periods that are required. And so we, as we get into doing the PPDR, we ought to watch those time periods and make sure that we're trying to resolve if we can. If we can't, we go through the process. But another area I find a big concern is just because of the testing we've done related to financial assistance. When we've done internal audits, I have found that we often don't always have the good supporting documentation of why or how we prepared the financial assistance packet. And we're going to need that information if we go to PPDR. We need to understand how we pulled information together, why we were different, what were the unforeseen circumstances. We need that evidence notes to be able to say what happened in this process. So tracking it, documenting it, keeping it for the period of time that's necessary so that you can actually pull it out if the patient were to go to through the process. It also, I think the dispute, when you get into the revenue cycle management controls, is really thinking about how you prevent a bill to the patient. And we talked about statements earlier, but this is about making sure they don't go to collection or impose late fees. So we want to definitely have some controls in place that holds that patient's account and does not continue down the collection path. There are another areas around the payment plans. A patient can set up payment plans from the time they receive the GFE to start paying off or putting in, trying to pay off the balance that potentially will be occurring after they've had the procedure. They can still use the PPDR if it's over $400, the service for that provider. This can be confusing as the patient can proceed with the resolution process even if they've made partial or full payments toward the billed charges. So payments or entering into payment plans do not show an agreement to settle at that or any other amount. So it's something important to keep track of as well. And then we're going to bring up just the fact that you should make sure you're paying attention to your financial assistance policies and see if you apply those appropriately. And if you've gone through and done some negotiations with the patient as Kara was going over, but also any type of discussion you've had with them on how they can pay that bill. So we'll move it on to the next slide.
So I think this is our final polling question. Where do you think your greatest risk related to the GFE and PPDR processes are? So we have a number of options here. And I'll take this opportunity to just go back to the Q&A. One of the questions in here states that a hospital has about a 50% self-pay population, and they offer packaged prices for many of the services. Since they already get paperwork with that price, is a good faith estimate still required? So I'll ask this to Karen. I've seen this come up a number of times in slightly different iterations. I think it's a question a lot of people do have.
Yeah, so I would say a good faith estimate does apply. There are very technical requirements of the No Surprises Act, particularly in relation to good faith estimates. And it requires a very technical response of, these are all the bullet points that need to be hit. These are the disclaimers that need to be said. And so I recommend kind of within that package price, meeting all of those elements. Like I said earlier, you do not need to use the HHS provided forms, but you do need to admit all of the elements to them. So that would be a good opportunity to kind of make a new customized form for this process. Make sure you hit all the elements, but include it in the package you already give.
Great. And then one question about the PPBR process, where is that mailed to? So where should all of this information be sent?
I can answer that as well. So when the individual submits their good faith estimate and their bill charges, you are required on the good faith estimate to put your address. And so the SCR entity is going to rely on the address you put on the good faith estimate, and that's how they will contact you.
Great. Perfect timing, because our results are up. Most people are saying all of the above. And I think that's right. There are a lot of kind of new things or new workflows to implement here to get these new processes up and running. So I think it's honestly just going to take some time and training with especially administrative staff and the key stakeholders who actually are on the front lines talking to those patients. So just some takeaways here before we close. Potential refocus enforcement and oversight efforts. So right now we have a little bit of flexibility, but at some point there probably will be a bit of a shift. The government will start paying attention more to actually enforcing this. But right now, everyone is sort of working on just getting things up and running. We think that successful hospitals and entities are going to incorporate kind of patient and industry feedback to figure out what best practices are. This is going to be a bit of a morphing process, and you'll have to see what's working and be kind of nimble about changing your processes that are in place or that you might be testing out. So ability to change and adapt quickly, monitoring the controls for gaps. So if something does go wrong, figuring out, was this a one-off fluke or is this a systemic issue that needs to be changed? And really relying on a good technology foundation to help track all of this. Lori mentioned some of the auditing earlier, and being able to prove what you showed the patient, how you collected all that information. So having all of that ready at your fingertips is kind of a good goal to have. And a lot of these are overlapping with some of our takeaways and suggestions from the webinar last time when you're providing estimates for notice, consent, and disclosures for patients being billed for out-of-network procedures. So let me pause here to give the CLE code, which is, I think, on our next slide. The CLE code is LZ5FM. That's up here. So please complete your attorney affirmation. For anyone seeking CLE credit, please submit your attorney affirmation form and return it to Patrick. His email address is up here right after the program. Disclaimer, I'm from Massachusetts, where we do not have the CLE requirements, so almost slipped my mind there. But please do send that in. And then here are some links to important forms and resources, including definitions and the CMS template, good faith estimate, and PPBR forms. Even if you do decide to create your own and deviate from these CMS forms, we recommend at least looking at them to make sure you're still meeting all of the elements that are required here. Additional resources, we'll put in a little plug to subscribe both to the Moss Adam Insights and Foley's Healthcare Law Today blog. The No Surprises Act is a morphing space. Everyone is still working to figure it out. There's guidance coming out still on a pretty regular basis. We expect towards the end of the summer to get more guidance, especially on the commercial insurance side, as to what certain estimates may look like. So we recommend subscribing here to stay up to date on what those developments are, because we will be keeping you updated. There is our contact information. So thank you everyone for joining us today. As we mentioned before, the questions we didn't have a chance to get to, we will be reaching out to email you with responses. All right. Thank you for joining us. We hope everyone has a great rest of their Tuesday.